An unprecedented legal showdown has captured the nation's attention, pitting one of America's most prestigious universities against the full force of the federal government. Harvard University and the Trump administration are locked in a high-stakes court battle over more than $2.6 billion in frozen federal research funding. This is no mere financial squabble. It's a profound conflict over the very soul of higher education, academic freedom, and the government's role in shaping campus life. The case, now before a federal judge in Boston, asks fundamental questions about whether taxpayer money can be used as a lever to enforce political will on universities, potentially setting a precedent that could reshape the landscape of American academia for generations to come. The dispute has escalated far beyond the confines of a courtroom, becoming a flashpoint in the country's ongoing culture wars. Former President Donald Trump has publicly lambasted Harvard, calling it anti-American and attacking the presiding judge, turning a legal proceeding into, honestly, a political spectacle. This intense rhetoric has raised the stakes immeasurably, transforming the case into a symbol of the deep divisions over the purpose and direction of elite institutions. For many, this is more than just a story about Harvard. It's a test of whether universities can maintain their independence from governmental pressure and uphold their commitment to free inquiry in an increasingly polarized political environment. The world is watching to see who will prevail. The legal proceedings, which began in earnest on July 21, 2025, have drawn a clear line in the sand. On one side stands Harvard, arguing that the administration's actions are an unconstitutional power grab, a blatant attempt to silence dissent and control internal university affairs through financial coercion. The university contends that this is a direct assault on the First Amendment, which protects academic freedom. Representing the university, lawyers have painted a picture of a government acting arbitrarily, bypassing established legal procedures to punish an institution for political reasons, an action they claim is both illegal and a dangerous overreach of executive authority. They insist this is not about a contract, but about fundamental rights. On the other side, the Trump administration frames the issue in starkly different terms. Government lawyers argue that this is simply a matter of contractual enforcement. They assert that federal funding is a privilege, not a right, and that the government has the authority to ensure taxpayer money does not support institutions it deems to be failing in their duties, such as combating antisemitism. According to the administration, Harvard has allowed a hostile environment to fester on its campus, and withholding funds is a legitimate tool to compel compliance with federal priorities. This defense positions the government as a responsible steward of public funds, protecting civil rights where the university has allegedly failed to do so. The origins of this monumental conflict trace back to the aftermath of the October 7, 2023, Hamas attacks on Israel, which ignited fierce debate and protest on university campuses across the country. In the spring of 2025, the Trump administration took the dramatic step of freezing Harvard's federal research grants, citing the university's alleged failure to adequately address incidents of antisemitism. The White House claimed that Harvard had fostered an environment where Jewish students felt unsafe, and that the university's leadership had not done enough to curb anti-Semitic rhetoric. This move was justified under a January 2025 executive order aimed at combating anti-Semitism, effectively linking the university's campus climate directly to its eligibility for federal research money. The financial impact of the freeze was immediate and immense. Over $2.6 billion in funding was suddenly put on ice, jeopardizing more than 950 individual research projects. This figure includes Media Group, Federal Grant Award Ceremony, Scientist Holding Research Grant Letter, U.S. Government Check for Research Funding at Stock at Distribute_Equally, $2.2 billion in research grants, and an additional $60 million in federal contracts. The cuts threatened a vast array of scientific and medical research, including Media Group, scientists working in cancer research lab, doctor examining Alzheimer's patient, medical research team with U.S. veterans at Stock at Distribute_Equally, vital studies on cancer, Alzheimer's disease, and veterans' health. Even a $12 million grant from the Defense Department, flagged as critical for studying biological threats, was caught in the crossfire. The sheer scale of the funding freeze sent shockwaves through the academic community, highlighting the profound dependence of major research universities on federal support for their most ambitious projects. In response to the government's accusations and demands, Harvard found itself walking a tightrope. The university vehemently denied the charge that its actions were politically motivated retaliation, instead filing a lawsuit that framed the funding freeze as an unconstitutional assault on its autonomy. Internally, however, the university took steps to address the concerns raised. Media Group, University Bulletin about updated protest rules, student protest leaders meeting with administrators, new campus policy announcement @distribute_equally, updated its rules governing campus protests, expanded antisemitism training for students and faculty, and, in a move seen by some as a concession, removed the websites for several campus centers dedicated to minority, LGBTQ and women's groups. The White House publicly acknowledged these actions as a goodwill gesture, but maintained its pressure for more sweeping changes. The administration's demands extended far beyond the issue of antisemitism, seeking a fundamental overhaul of Harvard's core operations. The White House called for media group, boardroom with university leaders discussing reforms, campus governance meeting, stacks of university policy documents @distribute_equally, sweeping reforms in university governance, a shift towards what it termed merit-based hiring and admissions practices, and the complete discontinuation of all diversity, equity, and inclusion programs. These demands made it clear that the administration's goals were broader than a single issue, aiming to reshape the university's policies to align with its own conservative ideology. This escalation turned the funding freeze into an ultimatum: either transform your institution or forfeit the federal support that underpins your research mission. When the case reached the courtroom of U.S. District Judge Allison Burroughs, the arguments presented by each side laid bare the philosophical chasm between them. Harvard's legal team, led by lawyer Stephen Lahotsky, argued that the administration was engaged in a blatant and unrepentant violation of the Constitution. He asserted that the freeze violated both the First Amendment's protection of academic freedom and Title VI of the Civil Rights Act. Lahotsky contended that the government was trying to force Harvard into an unconstitutional bargain: surrender its control over internal policies regarding admissions, hiring, and campus speech, or lose billions in critical funding. This, he argued, was not a contract dispute but a coercive and punitive act. The government's lawyer, Michael Velchik, presented a counter-narrative that focused on contractual obligations and executive authority. He argued that the administration was well within its rights to terminate funding that no longer served the public interest, particularly when it came to combating anti-Semitism. Velchik portrayed federal grants as a privilege contingent on compliance with agency priorities, not an unconditional right. He asserted that taxpayer funds should not be directed to an institution besieged by anti-Semitism, framing the government's action as a necessary step to uphold civil rights and ensure fiscal responsibility. This argument attempted to sidestep the constitutional questions of free speech and academic freedom by defining the issue as a simple matter of administrative discretion. Judge Burroughs, an appointee of former President Barack Obama, actively challenged the government's position during the hearing. She pressed the administration's lawyer to explain the direct connection between cutting funds for scientific research, such as cancer studies, and the stated goal of fighting anti-Semitism on campus. Her questioning suggested skepticism about the logic of the government's approach. Judge Burroughs expressed deep concern about the potential precedent this case could set, warning that using funding cuts to penalize institutions for speech-related reasons could have staggering consequences for free speech and academic inquiry across the entire nation. Her comments hinted at the broader constitutional implications at stake. The judge's pointed questions highlighted the central weakness in the government's case: the apparent disconnect between the problem and the solution. By cutting off funds for everything from neurodegenerative disease research to public health studies, the administration's actions appeared to be a blunt instrument used for a highly specific political purpose. Judge Burroughs seemed to signal that the government could not simply declare a contract breached without a clear and rational basis, especially when fundamental constitutional rights were in play. While she has not yet issued a ruling, her courtroom statements have given observers a clear indication of her deep unease with the administration's far-reaching claims of executive power over academic institutions. The immediate and most tangible consequence of this standoff is the immense disruption to scientific progress. Hundreds of research projects, many of which have been years in the making, are now in jeopardy. Studies aimed at finding cures for diseases like cancer and Alzheimer's, improving the health of military veterans, and preparing for future public health crises, face an abrupt and uncertain future. While Harvard has attempted to self-fund some of the most critical projects, university officials have admitted this is a temporary and unsustainable solution. The freeze threatens not only the work of established researchers, but also the careers of countless graduate students and postdoctoral fellows whose futures are tied to these federally funded grants. Beyond the laboratories, the case carries profound implications for the principles of academic freedom and university independence. If the government is allowed to use federal funding as a tool to dictate university policies on hiring, admissions, and campus speech, it would set a chilling precedent. Other universities, many of which have also had federal grants frozen, are watching this case with trepidation. A victory for the administration could embolden future governments to use financial leverage to punish any university whose campus culture or academic priorities fall out of political favor. This would fundamentally alter the relationship between the state and higher education, potentially transforming universities from independent centers of inquiry into instruments of the reigning political ideology. The outcome of this legal battle will reverberate far beyond Harvard's campus in Cambridge, Massachusetts. The judge's decision, which she has promised to deliver as quickly as possible, will likely be appealed by the losing side, with the administration strategists already vowing to take the fight to the Supreme Court if necessary. This ensures that the core questions raised by the case about the limits of executive power, the meaning of academic freedom, and the role of universities in a democratic society will remain at the forefront of national debate. The final ruling will establish a major legal precedent, defining the rules of engagement between the federal government and all American universities for years to come. Ultimately, this is a story about more than just one university or one administration. It is about the future of knowledge and discovery in the United States. At stake is whether scientific research can be insulated from political pressure, and whether universities can remain places where a wide range of ideas can be debated without fear of governmental reprisal. As the nation awaits the court's decision, the case of Harvard versus Trump serves as a stark reminder of the fragile nature of academic freedom and the constant need to defend the institutions that are dedicated to pursuing truth, no matter how inconvenient or politically unpopular that truth may be.